Oh, thank you, Madam Chair. I do have some questions about this, and it may seem relatively technical with this clause 18 making what looks like a minor amendment to delegated legislation, namely the Family Court Rules. It ties in with section 123B of the Sentencing Act, and that provision in the Sentencing Act 2002 essentially says that if an offender is convicted of a family violence offence and is not currently in force a protection order, then the court may order a protection order. That makes perfect sense. But this actually does something quite significant in conjunction with clause 14 of the bill as well. But what it does is it extends that power to people who are not convicted of an offence. So the court can put in place a protection order under this rule change where the person is either convicted of an offence or have been discharged without conviction for an offence. Now, don't get me wrong, there's a real place for protection orders in the absence of conviction, but where violence is proven. But where there's a discharge without conviction, that discharge may occur for any number of reasons. And I'm wondering, Minister, whether this is an acknowledgement that because of these ridiculous sentencing rules that you're putting in place, judges are going to have to default to discharges without conviction because they've got a choice between a sentence which is entirely unfair and providing a discharge without conviction. And that's a really problematic dilemma for them to be in, because if we've got a victim of family violence, we shouldn't be giving powers to the court to make what are in a sense punitive orders where there is a discharge without conviction. So I have real concerns that you've caused essentially a distortion in the law here by saying you might get a discharge without conviction, but we're still going to impose an order on you even though you have not been found guilty of that offence. And the reason, the underlying policy reason is because you know that discharge without convictions are going to rise. And there will be situations where under the current law people wouldn't get a discharge without conviction. But because the job of when considering a discharge without conviction, the job of the judge under the Act is to actually determine whether a conviction would be disproportionately severe. And because you've just turned up the temperature on all of these sentences, it's much more likely that it will be disproportionately severe. So you've got yourself into a pickle because the discharge without conviction will be there, but we know in fact that the offence occurred. It's only the sentence that the judge would be compelled on conviction to impose, which makes it entirely disproportionate to enter that conviction. So we've got a real dilemma. And in fact, this is the kind of thing that's going to happen. People are going to be less safe in this kind of situation because of these discharges without conviction. And you've now got a situation where you've got protection orders which should follow conviction, now following from discharges without conviction. Now, I'm aware that a discharge without conviction usually requires the offender to accept responsibility for the offending, but it is the opposite, of a finding of guilt. It's a finding that says the court is not interested in intervening here for whatever wider policy and justice reasons. We are going to discharge this matter. We're going to send it away. We're not going to make a finding adverse to you, nor are we going to find you not guilty. We're simply going to discharge you and bring this matter to an end because in terms of wider policy issues and the justice of this particular case, that's the right thing to do. And so you've got yourself into a real bind here because that's going to happen a lot. And I'm wondering if that's really why you've done this with protection orders.
Well, thank you for the wide speculation by the previous member on the potential elements of this. This is quite a very tightly detailed piece of the legislation. And in terms of protection order, it is important that if a judge considers the conduct warrants a protection order, that they can grant one, and that's what this clause refers to. That prevents victims having to make a separate application for a protection order and saves court time, which is better for the victims of crime.
Okay, so that's an interesting aspect that Duncan Webb's brought up, but it does feel like Paul Goldsmith brushed it off.
Yeah, I mean, Duncan is just reflecting what's again in the regulatory impact statement, and why the ministry's preferred approach is the status quo, because this is one of the unintended consequences that may arise for limiting the repeated use of discounts. An increase of discharges without conviction if disallowing a further discount for youth or remorse would lead to unjust sentencing outcome. That's an actual quote.
Yeah.